Good morning. Thank you guys for joining for today's webinar, What is Life After Coronavirus? Regulation Updates, Understanding Employer Compliance and Safety, presented by Rea Associates, a top 100 regional CPA and business consulting firm with offices across Ohio. My name is Imani Fields, and I'll be moderating today's presentation. Before we get started, there are a few housekeeping items to cover. First, if you have any questions during today's presentation, you may enter them into the chat box on your screen. We will try to answer as many questions as we can at the conclusion of today's presentation. However, to be respectful of your time, we know that we will not be able to get to them all. Therefore, following today's webinar, we will review all questions and send out the answers via email as soon as we can. When you receive this email, you will also receive the recording of today's presentation, as well as a link to participate in a very short evaluation. Please take a few minutes to share your thoughts about the presentation as a whole, the information provided, and our presenters. Your feedback is important to us as we continue to determine webinar topics related to the current COVID-19 crisis. Also, if you would like a copy of today's slides, you will find that they're available in the handout section of the webinar dashboard on your computer screen. Please note that the resources presented today are for informational purposes only. Rea Associates does not provide legal advice and will not make management decisions for your organization. You are encouraged to consult with legal counsel of your choice prior to implementing any policies or procedures within your organization. Today's webinar will be given by Renee West, Darlene Finzer, and Cheryl Koblenz. Renee West is a senior manager and leader of Rea Associates HR consulting practice. With more than 27 years of experience in human resources, Renee specializes in assisting organizations within the manufacturing, nonprofit, contingent staffing, food, and other industries with their HR challenges. She is also currently serving on the Ohio Society for Human Resource Management's Board of Directors as Central District Director. A principal and director of later life planning services at Rea Associates, Darlene Finzer has more than 30 years of experience in the accounting industry. Darlene specializes in assisting organizations with legacy family planning, retirement readiness, financial fitness, and fiduciary responsibility. She has also been featured in several publications, including Benefits Pro and Thompson Newsletter. Finally, Cheryl Koblenz is a senior manager at Rea Associates with more than 20 years of experience in the accounting industry. Cheryl specializes in assisting organizations to understand what they would like to achieve and consult them on what's going to take them to get there, as well as tax implications of those decisions. Today, Renee, Darlene, and Cheryl will hone in on the updated regulations and policies such as the CARE Act and shared work resources, and how you can protect your organization, your workforce, and their families during today's COVID-19 crisis. Take it away, ladies.
Thank you, Imani. Good morning, everyone. This is Renee West. We would like to thank you for taking time to attend today's webinar. We also hope that you, your families, and your employees are continuing to remain healthy during these times. Our goal today for our presentation is to provide you and your organizations with the most current and accurate resources. As we've stated before in previous webinars, a lot of the information we are covering continues to evolve and move forward as we move through the next couple weeks. Today, we'll be talking and providing further specifics in reference to FFCRA and all the paid leaves and what that means to you and your organization. We'll also talk through the CARES Act, Shared Work Ohio program, touch base on the unemployment and how all this impacts that, and also answering some of the key questions that we've received from clients in reference to these topics. And we will also provide you with resources to ensure compliance at your workplace in reference to the updated Department of Labor workplace posters and policy notifications that are effective today. And also provide you, again, with continued resources through Rea's employer resource page and our COVID-19 task force as well. Next slide, please. First, we wish to provide some further clarification on the Paid Leave Acts and all the acronyms that are floating out there. I'm sure as all of us, we're looking at all these different abbreviations and what do they mean. So what we'd like to do is provide some further clarification on that as to where we stand. The Families First Coronavirus Response Act was the original legislation that has two main provisions. The first is the Emergency Family and Medical Leave Expansion Act, or EFMLEA. The second piece of this act is the Emergency Paid Sick Leave Act, which you'll see referenced as EPSLA. These are all effective today and apply to leave taken between today and December 31st, 2020. Next slide, please. As we look at the EFMLEA, keep in mind that there are regulations in place that this is for employers with fewer than 500 employees. Employees are eligible for relief under this act after working for the employer for at least 30 days. As we move through each of these slides, there's a lot of content, so in the sake of time and to share additional resources, please utilize the links that we have and also revisit the data as we go through. Next slide, please. The EFMLEA is available when an employee is unable to work or telework due to needing to care for a son or daughter under the age of 18, or when the child's school or daycare is closed due to the virus. Keep in mind the initial 10 days of this leave are unpaid. After that time, the remainder of the leave is paid. Next slide, please. The employee can elect to run his or her existing paid time off, like if they have existing vacation or sick leave, concurrently with this leave period. However, the employer cannot require this. So the way you word that in talking with your employees is let them know that they are eligible to utilize that existing time. However, you're not requiring it. If an employee qualifies for both EFMLEA and the emergency paid sick leave that we're talking about next, the employee may use the employee paid sick leave at the same time of the first 10 days of the EFMLEA that would normally be unpaid. Next slide, please. This is one of the slides that contains a lot of information. So this is in reference to after the 10-day unpaid leave period expires, how will the employee be compensated? The employee will be paid 2/3 of his or her regular rate under the Fair Labor Standards Act, multiplied by the number of hours the employee would normally work. The paid leave under EFMLEA will be a maximum of 200 per day and 10,000 in total for the duration of the leave. After the max is reached, the remainder of up to 12 weeks is unpaid. Next slide, please. So let's focus on the second piece of the Families Act, which is the Emergency Paid Sick Leave Act, or EPSLA. When is the employee entitled to this particular type of leave? And we've given you a number of criteria here for you to review. Employee cannot work or telework because of federal, state, or local quarantine or isolation. Employee's been advised by a healthcare provider to self-quarantine. They're experiencing symptoms of the virus. An employee is caring for a person subject to federal, state, or local quarantine that has been advised by a healthcare provider to self-quarantine. And also if they're caring for a son or daughter of an employee whose school or daycare is closed. Next slide, please. A common question that we see is, can an employee use emergency paid sick leave to cover the first 10 days of the EFMLEA leave that is unpaid? And if an employee qualifies for both of these leaves, the employee may use this emergency paid sick leave at the same time, so they could run concurrent. Next slide, please. So if we look at the compensation piece of this act, how much compensation will an employee be paid during the emergency paid sick leave? And as we have here, there's a number of criteria and information for you as to how that is paid. It's paid at the employee's regular rate of pay, subject to a limit of $511 per day and $5,110 total. And you can look through and see the different requirements for this leave as well. This is employees subject to, again, quarantine or isolation. they've been advised by a healthcare provider to self-quarantine, and the employee is experiencing symptoms of the coronavirus and is seeking medical. And this leave, again, is the next leave will be 2/3 of the employee's pay. Next slide. Leave taken for the following are paid at 2/3 of the employee's regular rate of pay, subject to $200 per day and $2,000 total. That criteria includes an employee who is caring for a person who is subject to quarantine or isolation order or has been advised to self-quarantine, and the employee is caring for a son or daughter of an employee whose school or daycare is closed. Next slide, please. So we've received a number of questions that are very common right now, so we'd like to provide some clarification and resource for you as it relates to these leaves. If providing childcare related paid sick leave and expanded family and medical leave at my business with fewer than 50 employees would jeopardize the viability of my business as a concern, how do I apply for exemption? There is information on our website. Document why your business with further than 50 employees meets the criteria set forth. As I mentioned, there will be further guidance from the government in more detail as to these regulations. So please continue to visit our website for those updates. Next slide, please. The next one is, may I take 80 hours of paid sick leave for my self-quarantine and then another amount of paid sick leave for another reason under emergency paid sick leave? And the answer to that is no. Keep in mind the total amount of leave available through this legislation is a maximum of 2 weeks or 10 days, or as you see, 80 hours for a full-time employee or for part-time employee, the average of their work hours in a typical 2-week period. Again, total number of hours for which you receive paid sick leave is capped at 80 hours under these acts. Next slide, please. Another common question is, are all leaves under family medical leave, which was the original legislation for leave here in the United States? No, the only type of family and medical leave that is paid is the expanded family medical leave and leave that we're talking about here today. This includes only leave taken because the employee must care for a child, spouse, individual that is ill due to COVID-19. The family medical leave existing qualifications and qualifying events still remain as they are. Next slide, please. Are paid sick leave and expanded family medical leave requirements retroactive? And that answer is no. Everything from today forward would be part of the paid leave process. What documents do I need to give my employer to get paid sick leave or expanded family and medical leave? There's current updates and information coming from the government as to what these forms are. So again, please stay tuned to our resource page as we are able to obtain those and upload those for your resource. Next slide, please. A very common question that we're receiving is, may I collect unemployment insurance benefits for the time in which I receive paid sick leave and or expanded medical leave? And the answer to that is no. If your employer provides you paid sick leave or expanded leave, you are not eligible for the unemployment insurance. We have provided a website there for you to access that it does vary by state. So should you be out of the state of Ohio, this resource link will help you to answer that question. Next slide, please. As we mentioned, I know this is a lot of information. Again, please utilize the website that we've listed here as on the Department of Labor as one of the additional resources to assist you with questions related to these leaves. And also, please continue to monitor and look at our updated website that's going to be the most recent resource for you. At this time, I would like to turn it over to Darlene Finzer.
Thank you, Renee. Good morning, everyone. Thank you for taking the time to join us this morning. During these times, we look to focus on the positive, so I wanted to share my positive of the day with you. Today actually marks my 29th anniversary with Rea Associates, so I want to thank everyone for sharing my anniversary with me today. Maybe we can enjoy some virtual cake during the webinar. We wanted to share some of the highlights of the recently enacted Coronavirus Aid, Relief, and Economic Security Act, also known as the CARES Act. Senate Republican leader Mitch McConnell stated, "This is not even a stimulus package. It is emergency relief." And I'm sure that many of you attending understand what he means by that statement. The Senate passed this bill last Wednesday, and it was followed by the House passing this act, or the bill, on Friday. The president indicated that he would be ready to sign as soon as this passed through the legislature, which he obviously did swiftly last Friday. It was unprecedented to move so quickly on a bill so large, especially with the House already out of session, and the logistics needed to make this happen with our social distancing. But we are currently living in unprecedented times. The result was a bill containing a $2.2 trillion with a T dollar price tag. We could go to the next slide, please. With a bill as large as this, there are several provisions. And as there were a number of considerations of what the American people and the economy needs. Therefore, in addition to some of the provisions that we plan to focus on today, the Act contains provisions to do things such as boost food assistance programs, allow certain changes to the retirement plan provisions, provide grants to state arts and humanities organizations, and one which I have come to appreciate even more as I am currently working remotely from rural America is a boost to programs to improve internet access in rural areas. One of the Act's provisions that will affect just about every family is relating to the stimulus checks. To put this in perspective, we saw stimulus provisions as we fought the Great Recession in 2008 and 2009. The 2008 stimulus checks, which equated to $600 for an individual or $1,200 for a married couple, had a total price tag of $120 billion, and that's with a B. In 2009, under the American Recovery and Reinvestment Act, $14.2 billion, again with a B, of stimulus checks were sent to essentially retirees, those collecting some form of Social Security, veterans benefits, or railroad retiree benefits. The total cost of the 2020 stimulus check payments under the CARES Act is $250 billion, again with a B, double what it was in 2008. That is because the stimulus checks under the CARES Act is double what they were in 2008. The stimulus checks are $1,200 for individuals or $2,400 for a married couple. There's also a provision that allows $500 for each child under the age of 17. These stimulus checks are based on income, so there are phase-outs based on the income reported on the 2019 income tax returns, or if you have not yet filed your 2019 income tax return, since we have the automatic extension until July 15th, it will be based upon the income on your 2018 income tax returns. As an extra bonus, the stimulus money you receive is non-taxable. It is estimated that the payments will be direct deposited around April 16th, so happy typical tax deadline day, provided that the bank information is available to the government. Otherwise, the checks will be sent via regular mail and obviously will be slightly delayed. If we could go to the next slide, please. So I don't want to go into a lot of detail regarding the loans available under the CARES Act. We actually have a separate webinar and other related resources on our website related directly to small business loans. Renee will be sharing information at the end of our presentation on where to find those resources. I did, however, want to share that there is much funding being made available under the CARES Act to assist businesses to make it through this time when they are unable to conduct business under normal measures. The SBA has different loan options available, but I wanted to mention the SBA's Payroll Protection Program, also known as PPP, which is a direct result of the CARES Act. There are restrictions and details that you will need to investigate further, but essentially this provides funds to allow business to pay essential bills, such as payroll, rent, utilities, and the like, even when revenue has dwindled because of the pandemic. Under PPP, there's also the ability to have this debt forgiven. Again, there are restrictions, but for businesses that are hard hit, this is definitely something that you should consider and investigate more. This program should be available starting this Friday, April 3rd. And just last night, the Department of Treasury posted the application and other supplemental information on their website. Coincidentally, they did make a change from what we had anticipated to see to some of the loan provisions as it came out in the final application and information last night. So everything is continually evolving. We do have information to the link for the application and the resources on our resource page. I would suggest that you move quickly on this if you find that this program is the right one for your business. I also wanted to mention that there are other funding mechanisms available for certain industries that are feeling deeper effects of this pandemic. In addition to restaurants and hospitality businesses, the airlines is taking a big hit. And I just wanted to share an example of what some of these businesses are seeing. At the end of January, I took a trip to Florida for business. My flight, the round trip cost was $330. Or if you break that down, it was about $165 each way. I had a friend who was in Florida before the stay-at-home order went into effect, and he was able to book a flight home from Tampa to Cleveland for a mere $18. That's almost a 90% decrease in fee from what I had paid just a couple of months earlier. If we could go to the next slide, please. And I know that this webinar is dedicated to employer compliance and safety, but I did want to briefly touch on some provisions included in the CARES Act for business owners who, by the way, are also typically employers. Please be aware that the Act contains provisions related to payroll taxes on wages paid during this year. There are also certain changes that were made relating to tax provisions for the business. So please be in contact with your tax advisor to discuss the provisions available and what option or options will work best for you. Next slide, please. The CARES Act also contains a provision known as Federal Pandemic Unemployment Compensation. This provision provides a $250 billion boost to unemployment. Last year, about this time, we experienced an unemployment rate at the lowest level in nearly 50 years at 3.6%. we had 3.3 million Americans file for unemployment benefits the week of March 15th through March 21st because of COVID-19, lifting unemployment in the U.S. to 5.5% already this year. Obviously, the Act needed to include provisions to address this sharp uptick in unemployment. Typically, there is a 1-week waiting period, which has been waived to allow money to reach individuals quicker. This unemployment provision expands the eligibility to those who typically would not qualify for unemployment benefits. The benefit under this provision allows individuals an additional $600 per week in unemployment benefits. This is in addition to benefits being paid under the state program, which is typically around 50% of an individual's wages. It is possible for an individual to receive more in unemployment benefits than he or she received as a paycheck while still employed, as a result from the state program being coupled with this new federal pandemic unemployment compensation. The CARES Act also will extend the benefit period an additional 13 weeks beyond what the state system pays, so an individual could collect the benefit for a total of 39 weeks. I would now like to turn it over to Cheryl to share information on the Shared Work Ohio program.
Thank you, Renee. Renee and Darlene, I guess. Good morning, everybody. I want to talk a little bit about how Ohio is implementing some of the funding that they're getting from the CARES Act. Specifically about the Shared Work Ohio program. This is not a new program to Ohio, but with the CARES Act, we are getting additional funding for this act, or for this program. What this program does is it provides unemployment benefits to employees who might otherwise not be eligible. If the employer is looking to reduce hours but not completely furlough or lay employees off, this might be a program to look at. Traditionally, if an employee has their hours cut between 20 and 30%, they're really not eligible for unemployment benefits. But with this program, unemployment will come in and subsidize some of those lost wages. One note, in order to be eligible for the program, it does need to be a reduction of between 10 and 50% of hours. Next slide, please. This is a program that's initiated by the employer, not the employee. There's an online application, and the entire program for a specific employer can last up to 52 weeks. A couple of pieces of information you're going to need when you go to prepare the application. You will need a start date. On their website, the unemployment office is indicating that they would really like 30 days notice, but they're going to try to push these through as fast as they can. And they will try to accommodate a start date that is quicker than 30 days. They're not giving us a time guarantee of when we will get through the entire application process. I'll talk a little bit about that again at the end here. Next slide, please. The other information that you need on the application is you need the names of the employees that will be impacted, the percent of hours that will be reduced, and there's a term that they used called units. In this application, we're using units to group employees together that will have a similar reduction in hours. It doesn't need to be a specific department or include all employees within a department. However, you must have at least 2 employees within a unit. So if you have some employees that you're looking to reduce hours by 20% and another group that you're looking to reduce the hours by 40%, there's your 2 units, and you would simply designate which employees fall within the 20% unit or the 40% unit. Next slide, please. After the application is approved and the program is started, the employer will be responsible to log in to the unemployment website and list the hours worked for each employee every week that is inside the program. Just to note, this is a little different from a traditional unemployment, where the weekly reporting completely falls on the employee's shoulders. There is a little bit extra here that the employer will need to do. But again, we're looking at providing a benefit to employees to help subsidize their lost income. Next slide, please. I mentioned timing a little bit, and that the Ohio Unemployment Office is asking for 30 days. As of this week, they are now listing on their website that while they would like extra time, they are committed to turning around applications within 1 week of receiving them. So I think this is kind of an acknowledgement that they really want these programs to continue. They want to be able to help employees who are still partially employed, and hopefully keep them partially employed rather than a complete layoff. A couple of additional notes: these plans can be modified after they've been approved, or if the employee's hours are reduced below 50%, it would transition into a traditional unemployment plan, and the plan would be terminated. There is no penalty for either terminating a plan or modifying a plan. Just a real quick note on the first slide that talks about the Shared Work Ohio program. There is a link that walks you through the application process. It's a PDF file. If you open the file, don't panic. It is 64 pages. However, there are a lot of screenshots, very detailed explanations. You can get through it pretty quick, but I also liked that they provided the detail for this is where you click when you're trying to go through and do the application. So don't let the size intimidate you. Bottom line, this is a program, this is Ohio's application of a program that really comes in and says, let's help our employees that are partially unemployed to get them some benefits to help subsidize income that they're traditionally used to depending upon. With that, Renee, I'll turn it back over to you for the next topic.
Thank you, Cheryl, and thank you, Darlene. One of the last topics we would like to focus on will provide you and your organizations a resource to ensure compliance with the Department of Labor and the workplace postings for the new regulations under the FFCRA. The requirements for posting this new update is effective actually today. We will be sharing resources on the next slide as to these particular posters. Basically, the requirements are with all Department of Labor workplace posters, they should be posted in a conspicuous place. Obviously, we know a lot of our organizations and individuals are working remotely. So a best practice that the Department of Labor is recommending is to send the new policies via email or add to your company's intranet for employee reference. The requirement is to share the new policies with all current employees and the poster as well. No need to share with employees that are recently laid off or prospective employees. And there's a resource page here listed that talks about questions as it relates to this particular requirement. Next slide, please. So there are two posters. However, one is only required for non-federal employees. You will see the links provided at the bottom. This is a free resource for you. You can download this poster and post it. There's also the opportunity to order posters through the standard online orders as well. However, from a compliance standpoint, this is the most reasonable and easiest way for you to ensure that this is completed. The second listing is actually the requirement for federal employees. And as you move forward, again, these resources are free, so we highly recommend that you utilize these. Next slide, please. As we mentioned, we have provided a lot of information to each of you. We would like to continue to reference that you visit our Rea COVID-19 resource page. And again, this will contain not only updated information from an HR perspective, but also in reference to other segments and services within our firm to assist you. We've also provided the link below for the unemployment and the standard questions and resources for your employees as well. We understand this is a lot of information. Next slide, please. We are happy to help you and your organization to, as we move forward, to put these policies into place, update your employee handbooks, and move forward as all this legislation continues. We appreciate everyone's time, and I'm sure there are a lot of questions. So at this point, I would like to turn it over to Imani to move forward.
Thank you. And now we will get into today's questions. So the first question is for you, Renee. Under Emergency Paid Sick Leave Act, does this only apply to private employers or does it apply to county governments as well?
It will apply to all employees, yes.
Great. And the next question here is for Darlene. In regards to the CARES Act, I am a dental office with 8 employees. I heard that dental offices might be exempt. Any truth to this as of today?
I have not heard that they are exempt. Is the question in regards to the unemployment piece of it?
I believe so, based off of what they asked.
Yeah, so I don't know if Renee, if you have any further information on that or not, but I have not heard where individuals or different businesses are exempt from that.
Thank you, Darlene. That is my understanding as well. I am not aware of that exempt status. I would recommend that they visit our resource page. There is one specific to the dental practices that would also be able to provide an internal Rea resource for you should you need to follow up on that.
Great, thank you. And then also for Cheryl, is the shared work program an option for public reimbursing employers?
There is some information out on the Ohio Unemployment website about how the shared work program would work for reimbursing employers. I don't believe the application process is exactly the same, but there is something similar.
This is a question for Renee. Are healthcare providers exempt from these 2 acts? And I believe they're talking about the Emergency Paid Sick Leave Act and maybe the EFMLEA Leave Act.
Thank you for that question. My understanding is I do not know that there is an exemption for those industries. I would recommend that they visit the Department of Labor website that we've prefaced as a resource for that.
Sorry, I didn't realize I was on mute there. Next question here is for Cheryl. Can an employer utilize the Shared Work Ohio program as well as apply for the Paycheck Protection Program?
My understanding is those are 2 separate programs. The Paycheck Protection Act does have some of the criteria is about maintaining wages. So they should talk to their lending officer when they're applying for the Paycheck Protection Act, but it would not disqualify them from using the Shared Work Ohio program.
Okay, and then off of that, for shared work, I'm sorry, go ahead. For shared work program, can you clarify what a unit is defined as? Would it be a specific service line, or could it just be all of those individuals which were reduced by the same percentage?
In reading through the guidance that Ohio's put out, they do not seem to indicate that it needs to be a service line or a department. My understanding is that it literally could be the group of employees affected by the same percentage. We can definitely list it in the application, and if Ohio doesn't like our application, they will come back and suggest the modifications. But there's nothing in the literature that mentions it needs to be department specific or service line specific.
Great. And then for Darlene, can the extended FMLA be taken intermittently?
Darlene, this is Renee. I can actually answer that for you. Yes, the new extended FMLEA can be taken intermittently.
And then also, for someone that goes on unemployment that has to apply to 2 jobs per week since the, I'm not sure what that one says, so we're going to skip that one for right now. Is the
Actually, I do have an answer to that, Imani.
Okay.
The 2 weeks or the 2 jobs, in reference to that was traditionally when you were on unemployment, you were required by the state to actively be seeking employment. At this time, that has been waived, so that requirement is no longer in place.
Great, thank you for answering that. And then also, if an employee has a planned maternity leave in April and May, would the EFMLEA paid time apply to their maternity leave once the baby is born?
That is a good question. The best practice is to keep, so you have an employee that is going to be on leave through maternity, which actually would qualify as a family medical leave, which is unpaid. During that time, when that individual is able to return to work and comes off of family medical leave, should there be an instance where they have an eligibility or would become ill with the virus, then, or meet any of the criteria in the leaves, from that return from original FMLA, if there was absences forward, if they met that eligibility, that would come into play. But any employees that are on existing leaves now through family medical leave basically still need to continue that until that is exhausted as it normally would be.
Great. And then in regards to EPSLA, please confirm that this does not apply to the governor-mandated shelter in place, but only to diagnosed COVID-19 cases.
That is correct. It does not mean because if the shelter in place is that everyone's qualified. You have to meet the eligibility of what's listed there on the slide.
And then also, is the payroll protection program accessed through your bank, or is it direct application to SBA?
That is actually through a bank. If you go to the resource that we now have on our resource center, it would have a listing of the banks, the vendors who are able to initiate that program. So initially, typically under this, it would have to be an SBA approved bank or lending institution, but I think they have expanded that just because of the need for businesses to apply. So, you know, you can check with your local bank. There are guidelines on our resource center that talks about what you should be asking the vendors or what you should be asking the banks.
Great. And then I have a question here. Will taxpayers who receive SS income and or SS disability receive stimulus money?
Yes, they absolutely will. If they are receiving that type of income and their income is not at a level where they are required to file an income tax return, because this is initially based on looking at the file tax returns for 2019 and 2018, then they will look at those receiving those Social Security payments, and they will also be receiving the stimulus checks.
Great, thank you. And If an employee is due back from maternity leave and place of employment, a restaurant specifically, is closed, can they apply for any assistance after the doctor releases for work?
Yes. So again, back to our previous question in reference to maternity leave. Once an individual is back and is able to return to work as normal, that completes the standard family medical leave requirement. Again, they would need to meet the criteria. Obviously, if a workplace is closed due to the virus, they would be eligible to apply for these benefits through the new law. Only after the actual date that they're able to return to work.
Thank you. And then for Shared Work Ohio, what percentage of wages are paid for the reduced hours? Is there a cap?
So the compensation for the reduced hours is based on the employee's normal weekly benefit amount. So there are caps involved. It starts with 50%. The normal unemployment benefits start at 50% of average wages with some caps. And then the reduction in hours is taken as a percentage against the 50% weekly benefit amount. You know, every situation is going to vary, but a rough rule of thumb would be to say that they're going to be compensated about half of what their regular pay would be for the hours that they've been reduced.
And also in regards to the shared work, our employees are used to working around 0 to 15 overtime hours. With the COVID-19, this has been cut and completely is causing hardship. Are these hours eligible for Shared Work Ohio?
Unfortunately, they are not. The Shared Work Ohio program only starts at hours below 40 hours a week. So, and it needs to be 10% of that. So it's 30, if an employee is working more than 40 hours a week on average, they would need to be cut to below 36 hours a week to be eligible to participate in the Shared Work Ohio program.
Great. And Renee, I believe this is a question for you. Based on the DOL website, healthcare providers, hospitals, nursing homes, et cetera, are exempt from the EFMLEA and the EFMLEA. So as not to put a strain on healthcare systems caring for those with health issues, does that provider need to put up the DOL poster regarding the two previously mentioned acts?
Thank you. I would suggest that based on the Department of Labor, if that's the stipulation that they have put out, if it is not related to your business, then at this point, I do not believe you would need to post that.
Great. And here's a question here. Is the federal unemployment automatically triggered with a state unemployment claim?
I can answer that. This is Cheryl. So the federal unemployment that is part of the CARES Act is funded by the federal government, but it will be administered by the state unemployment office. At this point, I'm not aware that Ohio has said how they will be administering that. They're still working on some of the unemployment benefits for self-employed and 1099 employees. We have seen some states that are issuing a second check for the $600. Other states are simply adding it to the weekly unemployment benefit, but we really haven't seen how Ohio is going to administer that.
Great, thank you. And then also, does the FMLA at least 50 employees within 75 miles eligibility requirement for individuals request to apply for FFCRA?
That is a good question, and based on what the regulations state at this time, the 50-mile or the radius and the total employees, that does not exempt individuals from the new law.
And then I have another question here. An employee was on FMLA from February 3rd through the 14th, 2020, then becomes eligible for extended FMLA. They expended 2 weeks in February, so they only have 10 left under extended FMLA. Is that correct?
That is correct. The existing paid time, the family medical leave is 12 weeks of time. So if an employee is off for, as you mentioned, 2 weeks, if and when they would need to take EFMLEA, they would have 10 weeks available. So that clock is still ticking because the new legislation is actually still a part of family medical leave. So they needed to put a requirement in there to ensure that there's not excessive time above the standard 12 weeks.
Great, and I have another question here. My company is an essential business and we have workers at high risk asking if they qualify for unemployment if they stay home. Our company has more than 500 employees.
At this time, the regulations state that companies over 500 employees are exempt from the leaves. So I would continue to look at the Department of Labor updates. However, even though, you know, an employer is above 500, there are still requirements that are in place for them to ensure a safe workplace for their employees.
Great, and then for someone that goes on unemployment that has to apply for 2 jobs per week, since companies aren't hiring right now, is there going to be a provision on this?
Yes, we actually spoke about that before. That was a standard requirement when individuals are on unemployment to be actively working or actively seeking work. Again, that piece has been waived.
And employers with less than 50 employees, are they exempt from the EFMLEA?
Employers have the ability to request an exemption. However, at this time, we are still awaiting government guidelines as to the process to do so. There are criteria and next steps. So again, continue to visit our resource page and we'll be updating that as that comes forth.
Great, and I'm waiting to see if any more questions are rolling in. You guys, if you have any more questions, we'll give you a few seconds to send those in. If not, we can end a few minutes early and I'll let you guys have a few last words to say before we conclude today. Looks like I got one more question here. If an employee has been working alongside an individual with COVID-19, as an employer, can we ask them to quarantine and are we required to pay them EPSL or tell them to file for unemployment?
Could you clarify that further? So they're working again with an employee that has COVID?
Let me go back to the question here. If an employee has been working alongside an individual with COVID-19, as an employer, can we ask them to quarantine or are we required to pay them the EPSL or tell them to file for unemployment? So it sounds like their employees were working together and the second employee, they need to know if they need to quarantine or take further action.
I would suggest that that employer reach out to their health department as to the best step in that process. I mean, traditionally, if you have an employee that has tested positive, there needs to be that notification, and then protection of the other employees in the area as well.
We had a few more come in here. So how do my employees file for FPUCs?
As we move forward with the process, the government will be providing us with forms as to resources. We expect that we should see something coming forward here in the next day or so that we'll be uploading to our resource page, and that will be a resource for employers to start to document these requests for leave.
Great. And can someone qualify for unemployment because they're scared to come to work?
No, individuals would need to ensure that, again, they meet the criteria and the eligibility for those benefits.
I have an employee off now, but it will extend through April 10th. Will they get a percentage of the $511, I'm assuming?
We would need to quantify what the employee is off for. Are they off on a previous leave or is it EFMLEA related? again, that ties into what type of leave they're currently on.
If an essential business, construction to be exact, but if a business is essential but have reduced work, does this eliminate eligibility for our employees for unemployment?
There is the option for employees to apply for unemployment due to reduced hours. And again, I would visit the JFS website. Cheryl, do you have anything else to add to that?
No, I would agree with what you said. This might, if we're not reducing hours below 50%, this might be a case where we want to look at a shared work program.
Right.
And then also, what are our legal obligations to employees that had a start date during the Stay Home Act and were not able to be boarded on due to the stay-at-home order effect? How does that affect the company?
That's a very good question, and actually I'm sure that's a very common question that a lot of companies are asking throughout the United States. At this time, there is nothing from a regulatory standpoint as to how to address that because we've never been through this before. I would say as a best practice, a recommendation could be, keeping in contact with that potential employee and letting them know due to circumstances. We are just waiting to see what the next steps are to possibly move forward with it.
Okay, and I have another question here. Is there any specific paperwork from a healthcare provider the employee must provide in order to take the EFMLEA leave or emergency paid sick leave, or can they simply claim self-quarantine for precaution?
That's a good question. Again, that will be part of the requirements for requesting leave. There will be something required from the doctors. However, we're still waiting to see what that guidance will be. A lot of physicians are backlogged right now. So, the traditional method of requesting documentation, I'm sure will vary, but there will be something that they will be required to show.
Great. And then I have 3 more questions here, and we'll conclude it after that. If we have a COVID case confirmed in an essential business, would employees be able to utilize EFMLEA if they choose to quarantine and seek medical diagnosis?
That is a question that I would refer to their legal counsel for. Those positive cases and the best practices, again, the health department is going to be the resource for that. There are employer obligations, of course.
As we are obligated as an employer to tell those off work already, are we obligated as an employer to tell those off work already about the paid sick and EFMLEA?
No, at this time, the regulation states if individuals are currently off work, they do not need to receive notice. However, if and when the employee handbook's updated and they return back to work, then they would need to receive that.
An employee has a fever and we told them to stay home. Are they eligible for 80 hours of PTO even if they didn't seek medical attention?
Again, they would need to meet the requirements of the paid leave, and if it's not directly related to the COVID, then they would not be eligible for those benefits.
Great. Thank you, guys. Did you guys have any last words that you'd like to say before we conclude the presentation?
We thank everyone for their time, and we know there are still a lot of unanswered questions out there. Our goal is to continue to provide you with updates, so continue to utilize the resources that we've provided to you, and be aware of, what information you're reading and ensuring that it's from a credible source, as there is a lot of information out there right now. So we thank you for your time.
All righty. Thank you guys for joining us for today's webinar, What is Life After Coronavirus? Regulation Updates, Understanding Employer Compliance and Safety. We hope the team was able to provide you with some valuable insights that will help you make sense of the current government recommendations stemming from the COVID-19 crisis. If you sign off today and realize that you have additional questions, you're always welcome to reach out to Renee, Darlene, and Cheryl directly. You can also contact any of our RAE team members by clicking on the People section of the firm's website at www.raecpa.com, and that's REA. Don't forget to watch your inbox for an evaluation survey, access to the recording of today's webinar, and more. Thank you again, and we hope that you have a wonderful rest of your day.